The very idea of who belongs to a nation is often decided at birth. In the United States, this principle has long been defined by the concept of jus soli, a Latin term meaning right of the soil. This legal doctrine grants citizenship to nearly anyone born within the territorial boundaries of a country, regardless of their parents' nationality or immigration status. It is a promise etched into the fabric of American law, a direct inheritance from English common law that was designed to ensure a clear and simple basis for allegiance. The simplicity of the rule, if you are born here, you are one of us, has served as a powerful engine of assimilation and national identity for centuries, turning the children of immigrants into citizens by their first breath. This principle was formally enshrined in the U.S. Constitution through the Citizenship Clause of the 14th Amendment, ratified in 1868 in the aftermath of the Civil War. The amendment declares, "All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside." This language was revolutionary, intended to overturn the Supreme Court's infamous 1857 Dred Scott decision, which had denied citizenship to African Americans. The amendment's text sought to establish an unambiguous national standard for citizenship, rooting it firmly in the physical ground of the nation itself, rather than in the complex and often exclusionary criteria of bloodline or heritage. However, the phrase "subject to the jurisdiction thereof" created a notable exception, one that highlights the complexities of sovereignty in the 19th century. This clause was initially understood to exclude the children of foreign diplomats, who remain under the jurisdiction of their home countries, and members of Native American tribes. At the time, Aboriginal peoples, the original inhabitants of the land before European colonization, were considered members of separate sovereign nations. Their allegiance was to their own tribes, not to the United States government that had systematically dispossessed them of their ancestral lands. This distinction meant that even though they were born on the soil, they were not automatically considered citizens under the new amendment. The path to citizenship for Native Americans was thus a separate and protracted journey, one that underscores the selective application of constitutional principles. It was not until the passage of the Indian Citizenship Act of 1924 that all Native Americans born within the United States were finally granted the rights and responsibilities of U.S. citizenship. This act was a belated recognition of their place within the nation, an acknowledgement that came more than half a century after the 14th Amendment had extended that same promise to nearly everyone else born on American soil. This history reveals that the seemingly straightforward rule of birthright has always been contested, its boundaries drawn and redrawn by political and legal battles over who truly belongs. The long-standing consensus on birthright citizenship faced its most direct challenge in generations on January 20, 2025. On the first day of his second term, President Donald Trump signed a controversial executive order aimed at fundamentally redefining the 14th Amendment. The order sought to deny automatic citizenship to children born in the United States to parents who are not U.S. citizens or lawful permanent residents. This move was not just a policy shift, it was a direct assault on the legal precedent established by the 1898 Supreme Court case United States v. Wong Kim Ark, which had affirmed that the 14th Amendment's protections extended to the U.S.-born children of foreign nationals. The administration's legal strategy hinged on a novel reinterpretation of the amendment's crucial phrase, "subject to the jurisdiction thereof." For over a century, courts have understood this to mean being subject to the laws of the United States, a condition that applies to virtually everyone on U.S. soil except accredited diplomats. The Trump administration, however, argued for a much narrower definition, contending that the phrase requires more than mere physical presence. They claimed it implies a complete and undivided political allegiance, suggesting that the children of parents who owe allegiance to another country, such as undocumented immigrants or those on temporary visas, are not fully subject to the jurisdiction of the U.S. and thus do not qualify for birthright citizenship. This reinterpretation aimed to create a new legal framework where citizenship is tied not just to the place of birth but to the legal status and perceived allegiance of one's parents. Under this proposed system, the simple fact of being born on American soil would no longer be sufficient. Instead, federal agencies would be directed to deny birth certificates and passports to newborns whose parents could not prove their own citizenship or permanent legal residency. The order immediately set the stage for a monumental legal and political confrontation, pitting the executive branch against over 150 years of established constitutional interpretation and practice. The potential impact of such a change is immense. According to recent estimates, approximately 153,000 babies were born in the United States in 2022 to parents without legal immigration status. Denying these children citizenship would create a new hereditary underclass of stateless individuals, unable to access the basic rights and protections afforded to citizens. State governments quickly raised alarms, arguing that such a policy would not only be unconstitutional, but would also have devastating practical consequences. They warned it could strip them of federal funding for essential services like Medicaid and create a public health crisis by discouraging parents from seeking necessary prenatal and postnatal care for their children. The executive order was met with immediate and fierce legal opposition, launching a cascade of lawsuits from civil rights organizations and state attorneys general across the country. The battle lines were drawn on February 25, 2025, a day of dual high-stakes legal arguments on opposite sides of the continent. In Seattle, a three-judge panel of the Ninth U.S. Circuit Court of Appeals heard arguments after a lower court judge had swiftly blocked the order, calling it blatantly unconstitutional. Attorneys for the Trump administration urged the panel to embrace their narrow reading of the 14th Amendment, while lawyers for Washington state and immigrant rights groups stood firm on the Wong-Kim Ark precedent, arguing that the president cannot unilaterally rewrite the Constitution. Simultaneously, the U.S. Supreme Court was convening to hear oral arguments in a set of consolidated cases, including Trump v. Casa and Trump v. Washington. Curiously, the initial question before the justices was not about the constitutionality of the birthright citizenship order itself. Instead, the court chose to first address a more procedural yet profoundly important issue: the power of lower courts to issue nationwide injunctions. These universal injunctions, which block a federal policy across the entire country rather than just for the specific plaintiffs in a lawsuit, have become a frequent tool for challenging presidential actions. The administration argued that this practice gives single district judges too much power, effectively allowing them to set national policy from the bench. The arguments before the Supreme Court revealed a deep ideological divide among the justices. The court's conservative wing, including Chief Justice John Roberts and Justices Kavanaugh, Barrett, Gorsuch, and Alito, expressed significant skepticism about the legitimacy of nationwide injunctions. They suggested that such broad rulings were an overreach of judicial authority and that more targeted forms of relief, like class action lawsuits, were the appropriate mechanism for challenging a policy on a larger scale. This line of questioning signaled a potential willingness to curtail the power of federal judges to issue sweeping orders that halt a policy in its tracks for everyone. In stark contrast, the court's liberal justices, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, warned of dire consequences if this judicial tool were eliminated. Justice Kagan cautioned that doing so would create a chaotic state-by-state patchwork of rights and create a catch-me-if-you-can system where the government could enforce a potentially illegal policy in any jurisdiction where it had not yet been sued. Solicitor General D. John Sauer, arguing for the administration, conceded that the legal basis for the executive order was novel, but maintained that the judiciary's power to intervene should be sharply limited, leaving the policy in place while its legality is litigated piecemeal across the nation. As of June 11, 2025, the nation holds its breath, suspended in a state of legal limbo. The Supreme Court has yet to issue its decision on the critical question of nationwide injunctions, and the Ninth Circuit has not ruled on the underlying constitutionality of the executive order itself. The fate of birthright citizenship, a principle that has defined American identity for generations, now rests in the hands of the 9 justices. Their forthcoming ruling on injunctions, expected by the end of the court's term in late June or early July, will have monumental consequences that extend far beyond this specific case, shaping the balance of power between the executive and judicial branches for years to come. Should the Supreme Court decide to limit or eliminate the power of federal judges to issue nationwide injunctions, the immediate effect on the birthright citizenship order would be profound. Even if the policy is eventually found to be unconstitutional, Such a ruling would likely apply only to the specific plaintiffs or states involved in the initial lawsuits. This would permit the Trump administration to enforce the executive order in every other jurisdiction, creating a fractured and confusing legal landscape. A child's citizenship could depend on the state in which they were born, forcing countless families to file individual lawsuits to secure their children's rights. This scenario would create a two-tiered system of belonging within the United States. In states like Washington or New Jersey, which have legally challenged the order, a child born to undocumented parents might be recognized as a citizen. But across the border in a neighboring state, another child in the exact same circumstances could be denied a birth certificate and rendered stateless. This legal chaos would place an immense burden on the court system and on families who lack the resources to navigate complex legal battles. The very promise of equal protection under the law, a core tenet of the 14th Amendment, would be severely undermined. Ultimately, the showdown over birthright citizenship is more than a legal dispute. It is a battle over the meaning of America itself. The Supreme Court's decision will determine whether the United States continues to be a nation defined by the inclusive soil-based principle of jus soli, or whether it shifts toward a more exclusionary model based on ancestry and parental status. While the legal arguments focus on jurisdiction and injunctions, the outcome will resonate in maternity wards and communities across the country, defining for a new generation who gets to be called an American. The verdict, when it comes, will mark a pivotal chapter in the ongoing story of the nation's identity.